Good morning and or almost afternoon. Thank you for joining us. Welcome to the quarterly sample policy update series. Today we'll be focusing on our June 2023 packet, which was released for districts on June 15th and for county offices the following week. I just want to take a moment to introduce our panelists and participants today. First, we have with us Bob Turk, who is our Chief Legal Counsel for District and County Office of Education Legal Services. I'm Tazita Stewarts. I'm the Senior Director of Policy and Governance Technology here at CSBA. We also have Barbara Leifman, who is our Director of Policy Manual Development. We also have with us Megan Russell, who's the Senior Policy Manual Consultant, also in Policy and Governance Technology Services. And then we have Mariela Martinez, who is our Senior Legal Services Attorney, along with Alex Worthy, who is also a Senior Legal Services Attorney in our District and County Offices of Education Legal Services Department. As I mentioned, we are happy to be presenting to you all today on the June update packet. Before we jump into that, I wanted to take a brief moment to just focus on a new service that we have launched, which we really think is going to help folks maximize on the product that we put out via Gamut, which is Gamut Policy Plus and access to our sample policies. We also have that partnership with our legal services department. And so a little bit of background, we created this brand new department. I think we're about a year or two in. The legal services department is able to provide direct legal services to district and county offices. And this partnership and kind of promotion here is to really emphasize the work that our legal teams are able to do for districts to create, modify, and I guess edit sample policies that come out of our policy department. The benefit to you all, if you are to enroll in the service, is you would be afforded 3 hours of attorney time free of charge for any new legal services clients, an additional 2 hours of legal advice. That could be on anything related to policy, so updates, or those could be how to refresh or revise or tailor our policies to your district. You can submit questions directly through Gamut or to legal services if you're interested in the service. And a little bit of background on the fee structure, that subscription is only about 10% of your annual membership fee. So if you're interested, please reach out to our legal team at legalservices@csba.org. I also wanted to kind of briefly overview the program itself. So as I mentioned, it's new. We have a number of attorneys at your disposal. That also gives you access to legal advice and counseling, custom policy writing, as I mentioned, as well as our legal resource library. So that's basically unlimited online access for any members of your team, giving you tools to prepare for bargaining. It also includes things like CBAs, MOUs, salary schedules, and legal resources. So we invite you to contact our legal team. And that's our legal services department at legalservices@csba.org if you're interested in hearing more about either the promotion to add to your Gamut Policy Plus subscription or to enroll in legal services independently. So with that, we are going to jump into our June updates. If you have not attended the series previously, these are all recorded, so you'll receive both the recording and a copy of the slides if you registered. And so I assume everyone on here today has registered. That's how you are attending. So yeah, if you have any other questions, we'll answer those at the end. You can pop them in the Q&A and we'll review them at the end of the slides. So as I mentioned, we're jumping into the June packet and Mariela will get us started.
Thank you, Tazita, and good morning, everyone. We'll now turn to a discussion of charter school oversight and the recent laws that impact this topic. So we have two bills to talk about here. First is Assembly Bill 181, which was signed into law in 2022. And then there's Assembly Bill 748, which was also signed into law in 2022. Let's get started with Assembly Bill 181 then. AB 181 added code section 52064.3 to the Education Code. And according to that section, schools, and this includes charter schools, that are identified by the California Department of Education as needing an improvement plan are required to complete an Individuals with Disabilities Education Act addendum. That addendum is adopted by the State Board of Education and relates to improvements in services for students with disabilities. And the addendum must be completed by the districts or the charter schools by January 31st of 2025. Moving on from the addendum requirement, there's a change in guidance from the California Department of Education, and based on that, AB 181 deletes the requirement to offer transitional kindergarten if the school offers a kindergarten program. And finally, AB 181 adds material regarding an exemption for eligible students with disabilities, and it exempts them from coursework and other requirements that are adopted by the charter school in addition to the state board or the statewide course requirements, and awards such students a high school diploma. So after briefly discussing that, let's also briefly discuss Assembly Bill 748. And AB 748 adds section 49428.5 to the education code. And that section requires that each school, including charter schools again, that serves students in any of grades 6 to 12 to create a poster. And the poster must identify approaches and resources about student mental health. And the poster must be prominently displayed in public areas that are accessible to and commonly frequented by students at each school site. AB 748 also clarifies that the charter school's policy on bullying and harassment must be posted on the charter school's website. I will be discussing 748, AB 748 in more detail later on in the webinar, but for now I'll pass it on to Barbara, who will discuss changes to board policy and exhibit 0420.41 regarding charter school oversight. Barbara?
Thank you, Mariella. Now we will look to see where the laws that Mariella educated us about fit into policy, as well as to discuss other updates that were made to the board policy and exhibit. Let's first look at the board policy. In the section Material Revisions to Charter, we added language to clarify that it is the governing board who determines whether a proposed change in charter school operations would constitute a material revision. We also added material regarding when the board may deny a request to expand operations, which requires either a finding that the proposed expansion would render the charter school demonstrably unlikely to serve the interests of the entire community, or that the district is not positioned to absorb the fiscal impact of the proposed charter school expansion. In making the finding that the proposed expansion would render the charter school demonstrably unlikely to serve the interests of the entire community, the board is required to consider the fiscal impact of the proposed expansion on the district, the extent to which the expansion would substantially undermine existing services, academic offerings, or programmatic offerings, and whether the expansion would duplicate a program currently offered within the district that has sufficient capacity for the students proposed to be served. In regard to the finding that the district is not positioned to absorb the fiscal impact of the proposed expansion, the district satisfies this requirement if it has a qualified interim certification pursuant to Education Code 42131, and the county superintendent of schools, in consultation with the county office fiscal crisis and management assistance team, certifies that approving the charter school would result in the district having a negative interim certification pursuant to Education Code 42131, or if the district has a negative interim certification pursuant to Education Code 42131, or if the district is under state receivership. We also added to the policy a small section called Location of Charter Schools, which includes a general statement that charter schools are required to be located within district boundaries, except when permitted to operate outside district boundaries pursuant to law. In the section Fees and Charges for Supervisorial Oversight, we added language that the district may only charge the charter school for the actual cost of supervisorial oversight up to 1% of the charter school's revenue when the district provides the charter school with facilities and charges the charter school with a prorated share. Next slide, please. Now let's look at the exhibit, which lists legal requirements that apply to charter schools and may be used by districts to monitor charter school performance. The more significant changes include adding that admission preferences may not result in limited enrollment access for students with disabilities, academically low achieving students, English learners, neglected or delinquent students, students experiencing homelessness, foster youth, students who are economically disadvantaged or on the basis of nationality, race, ethnicity, or sexual orientation, and that mandatory parental volunteer hours may not be the basis of a preference or a criterion for admission or continued enrollment. These last 4 points are ones that Mariella spoke to, but I will reference them briefly to highlight that they were added to the exhibit. We added the requirement for charter schools are identified by the California Department of Education as needing an improvement plan to complete an Individuals with Disabilities Education Act addendum relating to improvements in services for students with disabilities. We deleted the requirement for charter schools that offer a kindergarten program to also offer a transitional kindergarten program. We also added the requirement to exempt an eligible student with disabilities from all coursework and other requirements adopted by the charter school board that are in addition to the statewide course requirements, and award such student a high school diploma. And we added that each charter school that serves students in any of grades 6 to 12 is required to create and prominently display an age-appropriate and culturally relevant poster that identifies approaches and resources about student mental health. Now I will turn it over to Bob to talk about some new laws regarding certification.
Thank you, Barbara. So as you all probably know, pursuant to the Education Code, the Commission on Teacher Credentialing is responsible for establishing standards and procedures for issuing and renewing multiple subject, single subject, educational specialist, and other credentials, along with other certificates, permits, and approving applications for these. So in 2022, we saw 3 new laws that impact this process and what CTC does. So I'm going to quickly go over those 3 laws and then turn it over to Barbara to cover what happened in the policy and really in what happened in the regulation that was impacted by these laws. So the first one we're going to talk about is AB 210, and that amended Education Code 44300 to allow school districts to request a 1-year early childhood education emergency specialist permit. This would authorize the teaching of all subjects in a self-contained transitional kindergarten general education classroom setting. So it's kind of a lot there. The applicants actually have to meet 3 specific requirements in order for this emergency permit to be issued. First is the applicant must possess a baccalaureate degree or a higher degree from a regionally accredited institution of higher education. They must hold a valid CTC issued child development permit at the teacher or higher level. And they must satisfy subject matter requirements in accordance with Ed Code 44300. So this does provide a little bit of flexibility as we're struggling with teacher shortages and trying to staff up, but there are still some requirements that you need to fulfill for this. Next slide, please. Okay, so next up we have Senate Bill 1397. And this bill actually amended the same Education Code section 44300. And it requires CTC through July 1st of 2024, so just about 1 more year. It requires CTC to waive basic skills proficiency requirements for the issuance of an emergency 30-day substitute permit. We've seen throughout COVID and over the last couple of years, a great need for subs. And so districts have been taking advantage of the opportunity to bring in substitutes under waivers. And what this does is allows that to continue. The waiver, however, may not be used to satisfy basic skills proficiency requirements or for any other teaching credential, permit, or certificate. It's only for the emergency 30-day substitute. And then next slide. Okay, so finally we have AB 1876. And for this one, so pursuant to existing law under 5 CCR 80025.1, an emergency career substitute teaching permit could be issued, and that requires the individual to possess a baccalaureate or higher degree from a regionally accredited institution, and to also pass the CBEST unless they're exempted by state law or other regulations. What AB 1876 did was add Education Code 44300.5 5, which requires the district to actually go through a verification process and confirm that the applicant has either completed 3 consecutive years of at least 90 days per year of day-to-day substitute teaching in the district within the 3 years immediately preceding your application, or that they have completed at least 90 days per year of day-to-day substitute teaching accumulated from 1 or more districts participating in a consortium with the district in the 3 years immediately preceding the application. Or, next slide, please. If the County Office of Education is responsible for the assignment of day-to-day substitutes for the districts within its jurisdiction, then the applicant has to complete those 90 days of day-to-day substitute teaching within the county itself. So basically what this is doing is saying within the 3 years immediately preceding the application, you have to have met under one of these 3 circumstances, the day-to-day substitute teaching minimums here of the 90 days. So with that, I'm going to turn this over to Barbara, and she can talk to you a little bit how this impacted board policy and specifically administrative regulation, I think is where most of this landed.
Okay, thanks so much. So let's take a brief look at the changes we made to 4112.2 certification. We'll start with the board policy. We added to the first philosophical paragraph demonstration of competency in the subject matter to be taught to the attributes of certificated staff. In the section priorities for hiring based on unavailability of credentialed teacher, we added that the governing board is required to adopt an annual resolution that it has made reasonable efforts to recruit a fully prepared teacher before hiring in accordance with a specified hiring hierarchy, a candidate who is not fully credentialed. In the same section, we also clarified that the board's obligation to take action to approve a notice of intent to employ a provisional internship permit does not require that the item be an action item, but simply that the board take action. We also added to this section that the declaration of need indicate the number and types of limited assignment permits, as well as to specify each subject to be listed on the general education limited assignment single subject teaching permits and the target language on emergency bilingual permits. Next slide, please. Now let's turn to the administrative regulation. In the section Basic Skills Proficiency, we clarified that the district may charge a fee to persons being tested to cover the cost of developing, administering, and grading the district proficiency test. In the section Teaching Permit for Statutory Leave, we added administrative leave related to dismissal and suspension proceedings and military leave to the types of leaves for which the district may request the Commission on Teacher Credentialing to issue a teaching permit for statutory leave in order for that person to serve as an interim teacher of record. We added a whole section on early childhood education emergency specialist permits, also known as emergency transitional kindergarten permits. And this is based on AB 210, like Bob discussed, pursuant to which the district may request a 1-year early childhood education emergency specialist permit that authorizes the teaching of all subjects in a self-contained TK or transitional kindergarten general education classroom. The request to the Commission on Teacher Credentialing is required to include annual documentation that the district has adopted in policy and practice, a process for conducting a diligent search as defined in Education Code 44300, a declaration of need for fully qualified educators based on the documentation just explained, which needs to be adopted by the board at a regularly scheduled board meeting, verification that the district will provide the required orientation, mentoring, and support, and lastly, the board's receipt at a regularly scheduled board meeting of a report on the orientation, mentoring, and support just described. The district may request the Commission on Teacher Credentialing to renew this permit for 1 additional year, provided the following occurs. The applicant verifies current enrollment in a commission-approved teacher preparation program that will result in a credential authorizing teaching transitional kindergarten. The district submits a declaration of need for fully qualified educators in the same manner as described above. The district verifies that the applicant continues to successfully serve in the assignment on the basis of the early childhood education emergency specialist permit. And the district verifies continued orientation, mentoring, and support with reporting to the board in the same manner as described above. And we did include what Bob had described in the AR. I just wanted to highlight, since he spoke mostly about those in a little more depth, these parts that were provided for in more detail in the AR. Okay, so let's now turn to, I believe it's going to be Mariella.
Actually, it's Alex.
It's Alex. Okay,
No
sorry.
problem.
The instruction collaboration agreement.
Thank you, Barbara. So we're going to turn a little bit now to the instruction collaboration agreements. And we have some, actually 2 board policies and an AR that this has impacted. Megan's going to explain those a little bit later. But we've got 2 laws that I want to talk about with all of you. The first is Assembly Bill 185. And this is actually a 2022 law. It's the Education Omnibus Trailer Bill for the 2021-22 regular session. So there's a lot in that bill, but as it relates to instructional collaboration agreements, I wanted to focus on the school district of choice program. And this is in Education Code section 48300 through 48317. So just as a quick refresher, the school district of choice program so it's an elective program. Districts can elect to participate, and it allows students who reside in California to transfer to other districts who also participate in the program. Transfers must be accepted through random and unbiased systems, and students cannot be accepted for transfer based on athletic or academic performance, their physical condition, or their proficiency in English. So this program, the School District of Choice program, was set to end June 30th of 2023, but it is now extended through AB 185 through June 30th, 2028. So we've got a couple more years on this program. If a district wishes to participate in the School District of Choice program, the board must first annually adopt a resolution that establishes the number of students who can be accepted for transfer. And this is based on recommendations from the superintendent or a designee. And then the districts participating in the program must also register with the CDE. So that is the portion of the Assembly bill that we're going to cover in the board policies that Megan's going to discuss. And then we also have Senate Bill 941. It's another 2022 law, and it adds Education Code section 48345. So this bill states that the board may enter into an instruction collaboration agreement with other districts to offer courses or coursework to students from other districts who have been impacted by disruptions or cancellations to specified courses or teacher shortages. So this is specifically available for science, technology, engineering, and mathematics classes, as well as dual language immersion programs. So how exactly is this different from the District of Choice program? Well, this program allows districts to enter into agreements for students to attend individual courses rather than all the courses as a student of the district. One thing to note with this law is that the ADA remains with the originating district for purposes of state apportionment. And then this law is set to end on June 30th, 2029. So we do have quite some time for this law as well. So I'm now going to pass it off to Megan, who is going to discuss how these laws have impacted policy.
Thank you, Alex. So as Alex mentioned, these changes impact 2 policies. The first is interdistrict attendance, which is board policy 5117. And so for that, we have added a new section to the policy. It's called instruction collaboration agreements. And like Alex said, it is intended to permit districts to enter into an instruction collaboration agreement with another local education agency to offer students courses or courseworks who have been impacted by teacher shortages. And those are in this areas of STEM and dual language immersion programs. And like Alex said, the process for admission must be unbiased, and the districts may not consider academic or athletic performance, proficiency in English, physical condition, family income, or individual characteristics that are specified in Education Code 200. And if there are more students who are applying for spots in this program than seats, then there must be an unbiased lottery program. And all of those procedures and requirements are outlined in Board Policy 5117. There were also changes because in addition to STEM, this impacts programs for dual language immersion. We've also made changes to Board Policy 6174 and AR 6174, which is education for English learners. So we have added a section in Board Policy 6174 that permits a district to enter into an instruction collaboration agreement due to the teacher shortages, disruptions, or class cancellations to dual language immersion programs. And this policy cross-references Board Policy 5117, which is interdistrict attendance, which has more of the meaty details about the requirements and processes for utilizing those collaboration agreements. There's also been some additional updates to AR 6174 regarding reclassification of English learners. We've clarified the criteria used to determine whether an English learner should be reclassified and expanded some of those criteria. And then we've also expanded the details of post reclassification monitoring of English language students to ensure that they have not prematurely exited the program, that any academic deficiency incurred through participation in the English Learner Program has been remedied, and the students are meaningfully participating in the standard instructional program compared to students who've never participated in English Learner Program. And those are monitoring for 4 years following reclassification of the English learner students. And so with that, I will hand it over to Mariella to talk about mental health.
Thank you, Megan. Let us now turn to that. And here we have 3 bills to talk about. First is Senate Bill 1414, which was signed into law in 2021. There's Assembly Bill 167, which was also signed into law in 2021. And finally, there is Assembly Bill 748, which became law in 2022, and which we already discussed somewhat in the context of charter schools. We will also talk about advisories from the U.S. Surgeon General. And because there are so many things to touch upon, I'm going to try to go through them as quickly as possible, while at the same time providing you with the necessary information. So let's get started. And we'll begin with the Surgeon General advisories. There are 2 of them. The first one is called Social Connection Advisory, and it emphasizes the critical role that social connection plays in individual and societal health and well-being. This advisory also provides recommendations for addressing consequences when there is a lack of social connection. And finally, with respect to this advisory, because schools play an important role in facilitating positive social connection, the advisory includes specific actions districts can implement. I'm going to go through these actions, and they include the following. Number 1, developing a strategic plan for school connectedness and social skills with benchmark tracking. Number 2, we've got building social connection into the health curriculum. 3, implementing socially based educational techniques. And 4, and finally, creating a supportive school environment. So with that, we're going to turn to the other advisory, which is called the Social Media and Youth Mental Health Advisory. And in the second advisory, the Surgeon General again speaks up and describes the positive and negative impacts of social media on children and adolescents, including the impact on mental health and well-being. This advisory recommends that schools develop, implement, and evaluate digital and media literacy curriculum to provide students and staff with the skills to strengthen digital resilience. So that's it for the Surgeon General advisories. Let's turn now to the bills, starting with Senate Bill 14. So this bill adds section 49428.15 to the Education Code. And according to that section, and subject to budget appropriations, the California Department of Education is required to recommend best practices and identify evidence-based and evidence-informed training programs for schools to address student behavioral health. And this includes staff and student training on recognizing the signs and symptoms of behavioral health disorders, such as common psychiatric conditions, substance abuse disorders, and alcohol abuse. The California Department of Education has, by the way, already identified such a training program. It is titled Youth Mental Health First Aid, and it is available on its website. So if we move on to the next slide, please. We are turning now to Assembly Bill 167, which is the discussion that will be the most brief here. And AB 167 requires that the California Department of Education, that is in consultation with the State Department of Healthcare Services and appropriate stakeholders, they must develop, subject to budget appropriations again, guidelines for the use of telehealth technology in schools, and that includes mental health and behavioral health services to students on school campuses. So finally, we're going to turn again to 748. As I mentioned, we touched upon this bill in our discussion about charter school oversight, but I want to get into it a little bit more in this context. If you recall, AB 748 adds section 49428.5 to the Education Code. And pursuant to that section, each school site serving students in any of grades 6 to 12 is required to create that poster, mental health poster, which must be age appropriate and culturally relevant, as Barbara mentioned, in the context of charter schools. And it must identify approaches, and it must share resources about mental health. And the poster must include certain information in order to meet the requirements of the bill. First, it must identify common behaviors of those struggling with mental health or who are in a mental health crisis. And that includes anxiety, depression, eating disorders, emotional dysregulation, bipolar episodes, and schizophrenic episodes. Second, a requirement for the posters is that it must contain a list of school site specific resources, including counselors, wellness centers, and peer counselors. Contact information for these resources must also be included in the poster. Third, and similarly, the poster must include a list of community resources, for instance, for suicide prevention, substance abuse, and child crisis. These community resources may include non-police mental health hotlines, public behavioral health services, community mental health centers, and the like. And again, as with the resources for schools, these community resources must have contact information, and this contact information must be reflected in the poster. Fourth, the poster must list positive coping strategies to use when dealing with mental health, such as meditation, mindfulness, yoga, breathing exercises, and the like. And finally, the poster must provide a list of negative coping strategies to avoid. And these negative coping strategies, not surprisingly, include substance abuse or self-medication, violence and abuse, self-harm, compulsivity, dissociation, catastrophizing, and isolating. A little bit more about the poster. There are a lot of requirements that go into meeting this provision of the bill. So the poster must be displayed in English. and any primary language spoken by 15% or more of the students at the school site. The poster can be no smaller than 18.5 by 11 inches and at least 12 point in at least a 12-point font. So they've gone as far as to specify that. Perhaps most importantly, though, it must be prominently and conspicuously displayed, and that is in public areas that are accessible to and commonly frequented by students at each school site. And these are bathrooms, locker rooms, what you would imagine, classrooms, gyms, that sort of thing. And finally, with respect to this bill, and wrapping up my section here, at the beginning of each school year, the poster must be distributed online to students through social media, websites, portals, and learning platforms. So as I said, that's it for me today. I'll turn it over to Megan, and she will discuss changes to Board Policy 5141.5 and Board Policy and Administrative Regulation 5141.6 regarding mental health. Megan?
Thanks, Mariella. So as Mariella just mentioned, there was quite a bit of information that has been added to Board Policy 4151.5 on mental health. The first is that we've expanded the first philosophical paragraph to include concepts that Mariella discussed that came out of the U.S. Surgeon General's 2 advisories. Some of the language that has been added now includes that the superintendent or designee shall develop strategies and services to reduce the stigma associated with mental illness, facilitate access to mental health services, and help students build resiliency skills, including digital resilience, increasing social connectedness, and cope with life challenges. So there's some big concepts included in mental health, very important, and that have been recently highlighted by the U.S. Surgeon General's advisories. Additionally, we've created a new section within the policy, and it's now entitled Information and Training. And this includes the required information and training programs to address student behavioral and mental health pursuant to SB 14. And as well as the notification to students and parents and guardians twice a year about how to access mental health services. And so there are specific procedures and ways that the district should be providing notice to students and parents or guardians, and those are enumerated in the policy. Additionally, as Mariella just outlined, there are details about the required posters for schools that serve any of grades 6 through 12. And all of those details that Mariella just mentioned are now included in this information and training section of policy 4151.5 on mental health. Additionally, we've added a new section about mental health counseling and referrals. And within this, it specifies that mental health and behavioral health services for students on campus may be provided by way of telehealth technology. And so next slide, please. Related to that, we have also updated Board Policy and Administrative Regulation 5141.6, which is school health services. And this, in addition to school health services, also deals with components of mental health as well. So we have expanded the first philosophical paragraph in the board policy as well to really highlight that the board further recognizes that schools are uniquely positioned to increase health equity and to help ensure that all students have access to necessary healthcare services. And again, to specify that districts may use telehealth as a delivery mechanism to increase access to healthcare services in school. And we've also added to the second paragraph about the importance of preventative programming and intervention strategies to address students' physical, mental, and behavioral health needs. So we're really emphasizing that in addition to physical health, that mental health and behavioral health are important critical components to overall student health and well-being. And then we've also moving on to the administrative regulation, we've included behavioral health services included in the list of types of health services that districts are able to provide students. And in addition, we have added that requirement for districts to develop a plan to ensure that individuals with speech, vision, or hearing disabilities are able to effectively communicate and participate in the Medi-Cal program. So that stems from some guidance and letters from the Department of Healthcare Services. And so the district is going to want to ensure that they develop a plan so persons with disabilities can participate in the Medi-Cal program. And finally, for the administrative regulation, we've also included that districts may seek reimbursement from a student's healthcare service plan when the district provides services or arranges for the provision of services for a student for treatment of a mental health or substance use disorder. And with that, I believe we will be turning to education for American Indian students with Alex and Barbara.
Thank you, Megan. Okay, so as Megan mentioned, we're going to shift gears now for education for American Indian students. And I'm going to talk about some new laws, and then Barbara is going to explain some changes to board policy and an administrative regulation as well. So the first law that was changed that I want to highlight is Assembly Bill 1703. And this again was a 2022 law. It adds Education Code section 33391. And basically this bill encourages districts to form a California Indian Education Task Force with Indian tribes that are local to their region or historically from that region to assist in the development of curriculum related to the local tribes and in the identification of and strategies to close achievement gaps between American Indian students and other students in the district. So the task force that can be created, they are intended to consider issues of mutual concern with the aid of providing accurate and culturally appropriate education, as well as closing those achievement gaps for the students in the district. If a district does create a task force, those task forces, okay, I'm having a moment there. They have to submit annual reports to the CDE, and then the CDE would in turn submit their findings across the state to the legislation in an effort to narrow the achievement gap between American Indian students across the state. So really the goal is to promote education statewide to better support American Indian students throughout the state. So what exactly can the task force discuss, and what issues can they discuss among themselves in an effort to solve? Well, we have those listed in the board policy. The first is curriculum materials about the history, culture, and government of local tribes, and developing such materials for use within the district that include tribal experiences and their perspectives. Also, they can discuss proper and improper instructional materials when these materials use depictions of American Indians. And then they can also discuss encouraging the adoption of the curriculum developed by the California Indian Education Task Force. And as I mentioned earlier, identifying the extent of and the nature of any achievement gaps between American Indian students and other students, and the necessary strategies to close those gaps. So that is Assembly Bill 1703. And then we also have Assembly Bill 740. It is another 2022 law, and it has amended Education Code section 48432.5. This bill provides protections for American Indian students prior to any involuntary transfer to a continuation school, prior to suspensions, expulsion proceedings, or assignments to supervise suspension classrooms. So existing law prior to AB 740 required that before a student was involuntarily transferred to a continuation school, the student's parent or guardian must receive a written notice advising them of their rights. AB 740 has now extended that provision for foster children and American Indian students. Now, if such a student is being involuntarily transferred to a continuation school or suspended or expelled, the written notice must be given to that student's educational rights holder, if applicable, their attorney, county social worker, or an American Indian tribal social worker. So this bill has extended the people who will receive the written notice of rights on behalf of an American Indian student, if that student finds themselves in a situation of being involuntarily transferred to a continuation school, suspended, or expelled. So I'm now going to pass it off to Barbara, who's going to discuss some of the changes that were made to policy and an AR as well.
Thanks, Alex. So here we go with changes we made to our policy materials. So we made a significant technical change, which is important to understand. The CSBA sample policy manual originally included Administrative Regulation 6173.4, which was called Title VI Indian Education Program, which was solely focused on the federal Title VI program. With the various provisions of new state law regarding the education of American Indian students, we thought it important to have a board policy on this topic, which is inclusive of state law as well as the federal Title VI program. In order to accomplish this, we deleted AR 6173.4, Title VI Indian Education Program, and adopted BP or board policy with the same number, 6173.4, Education for American Indian Students. Secondly, it's important to recognize that the terminology districts wish to use in this policy will be unique to each district, and districts should feel at liberty to revise the policy to reflect terminology preferred by the district and local tribes. So let's get to what's included in the new board policy. So we have a philosophical statement which reflects the board's recognition of the unique cultural, language, and educational needs of American Indian students that may be addressed by increasing student knowledge about American Indian history and by providing American Indian students with access to education and other services necessary for such students to meet the same challenging academic standards as other students. We also included the statutorily encouraged involvement of an American Indian Education Task Force pursuant to AB 1703, which Alex discussed in detail. So I will move on to other provisions in the new board policy, which include identification of and related supports for American Indian students most at risk of not meeting state academic standards. As Alex spoke about, additional protections for American Indian students prior to suspension, expulsion, assignment to a supervised suspension classroom, or involuntary transfer to a continuation school pursuant to AB 740. There is the provision of programs to facilitate the successful transition of American Indian students to post-secondary education and employment. Professional development to assist those working with students regarding the unique needs of American Indian students. Annual reporting to the board regarding the outcomes of American Indian students. And lastly, the new board policy contains a section on the federal Title VI Indian Education Program, which is the material that was formerly in the now deleted administrative regulation. I'm now going to turn it over to Bob and Megan to discuss Board Bylaw 9322 agenda meeting materials.
Thank you, Barbara. Okay, if you're a legal services client, or if you joined us for the March Update Packet webinar, or if you have attended any of our roadshow events we've been doing this summer, you've probably heard already a lot about Assembly Bill 2449 and how it impacts teleconferencing. We've covered that at length at all of these events, and if you have questions, we can talk about it some more. But under this section here, Megan's going to discuss a little bit of 2449 and some additional changes that resulted from that bill. And also she's going to talk about the changes from Assembly Bill 2647 and how it impacts board bylaws. But first, I'm going to give you a little background on that bill 2647. It impacts the distribution of agenda materials, supporting documents to members of the public. So as we all know, under existing law, no surprises here, Notice of a meeting must be posted 72 hours prior to the meeting at a location that's freely accessible to the public. The public also has to have access to the supporting documents that go along with that agenda. Now, the Attorney General back in the mid-90s said that weekend hours do count for that 72-hour window, and that freely accessible really requires that the agenda and the materials be at a location where they can be accessed and read by the public at any time. So those are two key things to remember here. So the Brown Act also requires the agenda, if you have a website, requires the agenda to be posted on your LEA's website. So at this point, everybody has a website. So taking these all in context, 72 hours prior to the meeting, you have to make all the materials accessible to the public, freely accessible at a location and also on your website. Next slide, please. And so AB 2647, what it really does is gives us a little bit of flexibility around this. It allows us to make records available online within that 72-hour window if we meet certain requirements. The bill actually arises from an appellate court decision, Sierra Watch versus Placer County. That was a case where Placer County, their board of supervisors, and a developer that they were working with, they reached an agreement fairly late on an environmental impact report that was going to be discussed and voted on at their upcoming board meeting on a Tuesday. It wasn't until after hours, I think it was 5:40 is what the court said, at about 5:40 in the evening, they reached consensus on this document on Friday. That was after the county clerk's office had closed. So the document was not able to be posted where the public could access it. So what they ended up doing is they prepared a copy of the document, the memorandum, they circulated it to council detailing the terms, and the board of supervisors had access to this document prior to members of the public, and members of the public were not able to access the record 72 hours in advance of the meeting. So the court actually ruled that this was a violation of the Brown Act because the public does need to have that access to the record 72 hours in advance. So what AB 2647 does sort of acknowledges what happened in that case and makes an effort to give us some flexibility to use technology and websites for distributing materials. The trick is you have to meet some pretty specific requirements in order to take advantage of this. So first, if you're going to distribute these materials via the internet within that 72-hour window, you must first release an initial staff report that contains an executive summary of the item itself, and it must include any staff recommendations so that the public has an opportunity to view those. That has to be made available at your designated location for inspecting records. So that has to be posted 72 hours in advance still. But the document itself can be posted on the website as long as it's done in a place and in a manner that makes it clear that it relates to the agenda item for the upcoming meeting. And the web address where that's listed needs to be posted on your meeting agenda. In addition, the physical document needs to be made available for the public to inspect at the beginning of the next regular business hours. But those business hours must be at least 24 hours prior to the meeting where the item is going to be discussed. So essentially, if you think about the Sierra Watch case, what this means is they could have posted that document online at 5:40 and made it available Monday morning when they open their office for the public to view. And they would not have been in violation of the Brown Act if their agenda indicated we post documents at this location on our website. And before 5 o'clock on that Friday, they had made a document available that was an executive summary with staff recommendations. So really what it does is allows you for these last minute items where you know the support materials are going to be coming in late. You can sort of front load and prepare by creating that executive summary while you're still finalizing that document, so long as you follow the additional requirements. And with that, I'm going to turn this over to Megan, and she can talk a little bit about some other impacts of 2449 and how 2647 impact board bylaws.
Thanks, Bob. So as Bob mentioned, we have a few updates to board bylaw 9322, which is agendas and meeting materials. So stemming from AB 2449, there's a requirement for boards to maintain and implement a procedure for receiving and swiftly resolving requests for reasonable accommodation to board meetings for individuals with disabilities. That's also included in board bylaw 9320, which is meetings and notices, but we've also added language to board bylaw 9322. Additionally, there are requirements regarding documents related to records of a statement threatening litigation against the district to be discussed in closed session, excuse me. And finally, as Bob just mentioned in detail, how boards can comply when the offices are closed with a portion of the Brown Act that requires writings or documents distributed to a majority of the legislative body less than 72 hours before a meeting, and also distributed to the public. And that's pursuant to AB 2647, the Sierra Watch litigation. And we have included the procedures and the details so boards can comply with the Brown Act if that situation comes up. And those are included in board bylaw 9322. So that's all I have on that.
Thanks, Megan. So to wrap up, we're going to talk a little bit about the county samples. So historically, CSBA has maintained both policies for county offices of education, as well as policies, samples that is for districts. Our county sample manual has been evolving over time and currently includes 83 county-specific board policies, regulations, and board bylaws. These are unique and distinct from the samples that exist in the district manual. So we just wanted to point you all in the direction of that if you are looking for, again, county-specific material. The remaining policies in the county sample manual have actually been written for district offices, but they may be adapted for use by county offices of education in areas where it's appropriate. And so it's important to review those district-specific policies to ensure that the content reflects the practices and applicable laws for the county office. The county office packets are released about a week after the district packets. So as I mentioned at the top of this, we released the June packet on June 15th, and then the county packet and any specific policies that are written for counties that had edits were released the following week after. And so I just wanted to briefly touch on the distinction so that you all are aware. Each of our sample policies contain note boxes. You all may be familiar with that. So you'll see for each district specific policy that counties may use, there's a disclaimer included at the top explaining that the document may or may not include the global changes that would reflect that they are being used by a county office of education, and really emphasizes that a county office using the policies would want to carefully review and revise the document so that it is appropriate for their use. There are also different types of designations that we make available for county offices. For example, superintendent policies or county policies. And so if you need more information or have questions about those designations, those policy types, or the district use policies and how to get access to them, please do reach out to our team. So in sum, we have updated 2 county-specific policies this time around. In this case, both of the edits mirror pretty closely the edits that were made on district policies. So I'm not going to go into detail about those changes since, again, we've covered these in the previous slides. But just to call your attention to the unique ones that are specific to counties, we have board policy in Exhibit 0420.41, that's oversight of county charter schools, and board bylaw 9322, agenda and meeting materials. So again, if there are any questions regarding those specific policies, please do let us know. And at this point, we're just going to shift over to questions that you all have. So I don't see anything in the chat that hasn't been answered. So now would be the opportunity to ask if you've got those questions. And I see we've got a quiet group today, so not sure if there's anything else we wanted to highlight from the team, upcoming webinars or update package, just so you all know we release these on a quarterly basis. The next update packet will be in September, and that will come out usually around right around the 15th of the month, and the following week for county policies. Are there any upcoming events in County Office of Education and District Legal Services, Bob, or webinars that you all want to make our attendees aware of?
Absolutely. So we actually take a little break in July from our Lunch and Learn series, and we'll be resuming this beginning of August. And we're actually going to be touching on a pretty hot topic right now, which is dealing with instructional materials and the removal of materials either from the classroom setting or from libraries or from curriculum. It's been a pretty hot topic. So we'll be covering that at the beginning of August. And then I just wanted to say again, just Tazita mentioned it at the top of the hour, but if you are a legal services client and you don't subscribe to Policy Plus, you might want to consider that, because you get 2 free hours of attorney time added on to your resources. And if you don't already subscribe to legal services, but you are a Policy Plus member, you might want to consider signing up, because you do end up getting, when you add a new service, you get these additional free hours. So if you're Policy Plus and you sign up for legal services, you get up to $1,000 of attorney time that we don't charge you from. 3 of those hours is going to be just general advice, and 2 hours specific to your policy editing needs. CSBA is sort of the go-to resource for policies, so it just kind of made sense for us to meld these together and let our attorneys be there to help you answer questions and customize these policies directly for the work that you do. So feel free to reach out to us if you have questions, and we'd be happy to let you know how you can get signed up.
Okay, thanks, Bob. And we do have one question from Colleen in the chat, and I believe this is probably on mental health. And she's asking if there will be a sample poster coming from the state or CSBA. And Colleen, if it's not mental health, please let me know and I can reframe the question.
Yeah, I'm assuming this is mental health as well. And pursuant to Education Code 49428.5, as added by AB 748, CD is required to develop a model mental health poster. I believe that's forthcoming. I don't believe that there is one that has been posted yet. And then also to answer Valerie's question, part of it, I misspoke and it's wrong on the PowerPoint, but it is policy 5141.5 for mental health.
Thanks, Megan. So the next question is from Valerie. I think this is also relating to your previous clarification, Megan, but Megan references 4151.5 on the updates, not seeing it on the summary. So hopefully that answers that part of your question, Valerie. The second part of Valerie's question is it okay to only have the agenda on the front page of the website with the agenda backup materials within the board webpage of the website? So exactly what materials need to be listed, I guess, on the first or front page of the district website?
That's a good question. Depends a little bit on how you have your website set up, but essentially what you have to post your agenda. It has to be in a non-contextual link on your homepage. So your next board meeting has to have that prominently displayed on your website. And it does specifically say the agenda. Any backup materials have to be provided to the public at the same time they're provided to members of the board. So you can do that a couple ways. If you link from the agenda directly to it, if you use a meeting management software like Gamut Meetings or Board Docs or something like that, you can have the link to your meeting management software. So you could have your Gamut Meetings link, they click on that and it goes directly to that specific meeting. And that's the way Gamut's set up. So as long as they have access to those materials and your agenda itself is on that homepage, you should be okay. But if you have specific questions, we're happy to take a look at your website and say thumbs up, thumbs down. You might want to make a tweak here or there.
Perfect. Thanks, Bob. I think that answers all of the questions. Going once, going twice. Hopefully you guys have our contact information. I'm going to put the slide up now for legal services, as well as their website, and then the 2 email addresses for questions about Gamut and policy. If you have questions about either the platform itself or content questions about the samples. So I don't think we have any more pressing questions. And if no one else has any further updates, we will see you all in September for this. Usually we host the webinar the last Wednesday of every month if you want to add those to your calendars in advance. So yeah, we look forward to seeing you then, and thank you for attending.